And I will now reopen for, just for a brief review. I don't, no, we need to vote on Youssef. I don't have my notes. We haven't voted on it, so we have to reopen Youssef for an executive session. And it's continued actually from a work session into an executive. So I'm opening, I closed, recess rather, the rooster till that date, and now I'm opening Youssef for a continued, and you have in front of you, I hope, the bolded version of the draft. You may have 2 copies of it. I tried, somehow or other I managed, yeah, you have a copy of it. It's the one in, I don't know what that is, Century or something, but it's got bolded. See, the whole section there from 2 to 5 is bolded. My note was to fill out the points related to, and I don't, let me dig up my other notes, but he had made a point, there's a generalized point, and I said, what specifically are we talking about here? And I need all the RSAs and all that sort of stuff. So I'm going to go through points 2, and I'm going to do this really efficiently, because points 2 through 5, and ask, as we have done with the rest of this, the rest of this stuff is your language. I apologize for not bolding all the changes that you asked me to put in. I forgot to bold them in this one. But that part there, I want to go through those points and ask for the documentation. Now, Mr. Beaker's not here. I wonder if it's up to be our Becky or whatever for RSA.
I'm not sure. I have them right here.
Right. Representative.
Is it the non?
No, it's the bolded one, and it's not the one. There's one that's in an Arial or something. It's not that one. Throw that one away. That was a mistake. It's the one that looks more like Times New Roman, except I think it's Century Bold or something. That font. It's a different font. It looks like this. It looks like this. It's not the Arial font. It's not the simple font. It's a serif font. So if you'll just go down, we're looking at, I'm going to just, everything else is the way you've requested it. So I'm going to look at point 2. Posited as fact, the psychological condition of the minor child without being an expert herself and with no expert psychological findings or report, and apart from any testimony that supplies with reliable principles and methods contrary to RSA 516, 29-A, 1B, in paragraph 2 of the same statute. And it's yeah, that's what you're going to look for. So we'll look at that statute as quickly as we can. But in the meantime, what is the how do you document that? Did that happen?
Yes, Mr. Chair. I have prepared to make this as efficient as possible a bundle containing 50 pages that I've bait stamped 1 through 50 for ease of reference. And I have one copy simply because with all due respect to the committee, I've made thousands and thousands of copies.
I don't want to go there. I just want to know what's in this one. What's in there?
This is all the evidence supporting every line of the claims made in the findings.
We don't want that. We just want the ones from 2 to 5.
Fine.
Okay. So you pull those out. If I'm going to copy them, I'd say to save some dollars.
Perfect.
Actually.
Excellent.
Would you do that as fast as you can? I'm going to give the committee a 10-minute break. Just come back exactly 20 after I'm going to start. I'm going to do the gavel exactly 20 after. Oh, this thing.
That's what you want. Once you bake it.
No, I don't want this. What is this? No, we want.
You asked him for a copy of just
Yeah,
those 2
50
points.
pages.
That's everything, Mr. Chair. That's,
No, I know that. But so from point 2 to point 5, this is all we need.
That's just for this first point.
We got 2 to 5. We need 2 to 5.
That's what you asked for.
Yeah, you just asked for this specific point.
No, I asked you 2 to 5. I want all the points.
Okay, yeah, because I didn't have your final version until after Kevin had left. So I do have.
All right, so
I do have supporting documentation.
I'm gonna recess yours and come back to it and open a different way.
No, Mr. Chair, that was good stuff. I thought make the copies of the other ones while you're going over these points.
You wanted to go forward.
This-
I have to recuse myself anyway. So I'm,
Oh, just in order to
she
use
keeps
But I need,
going.
him here.
And Mr. Chair, this document here does support all of your bold.
This is all we need, is one document?
This should be it, yes.
Oh, then we're set, okay. You're saying we're set?
right here, I
In the meantime, I'm gonna make copies of everything he has.
No,
That's what you.
Save a tree.
no, we don't want to cut the trees. We've already been to all, you almost tried to actually go through what we didn't do. That's these 2 to 5, and that's, he said it was covered.
That's what I thought.
No, he just said it's 0.2, so now he's saying it covers 2 to 5. You got that, yeah. All right, we are back.
You saw all of
We may have, we may not have, but these points were part of the report, so what we do with the report is we go point by point.
Right.
So for the benefit of everyone in this room, we go through the, did I reopen this? I did reopen. We go through the points that we haven't, that weren't part of the report. These are new points in the report, and we're gonna go through them and ask for the evidence that proves that it took place, number one, and the breach of RSA, the RSA that was breached in theory, or in allegation. So, Representative Caput.
Thank you, Mr. Chairman. If you go down to, you're talking about in your bold.
The bold in the first
If you go down to the 4th line of the bold, methods contrary to RSA 516, I would say 516:29A, 29 small a, period. Stop right there.
Okay.
There's no need to have the rest of that sentence. The chapter involved is only 2 paragraphs long, and the subparagraphs of that 516 are all part of that. So you're just, that's this unnecessary verbiage.
Okay, so it should say RSA in your fine, RSA 516:29A,
29 dash little a,
dash little a.
period. Just stop right
And
there.
there's, you say there's lots more, or are we?
No.
And what were your reasons for striking them? Because it's all covered?
Well, what you have there, you have a Roman numeral 1 in colons, which shouldn't be like that. It should just be a Roman numeral 1 if you wanted to spell it out.
Right.
And you don't need the subparagraph B and paragraph 2 of the same statute. You don't need all that extra verbiage because there's only 2 paragraphs.
Oh, you mean because you can see it with one blank, you can see it all right there in front of you?
Right.
Okay.
516 is only 2 paragraphs
Without
long.
objection of the committee, we just reduce that to A to 516:29 dash A. I don't have a problem with that, striking all that other stuff.
And then the next 2, I already checked it.
Both are
It's
just
fine with
What was I going to do? My pen is going so fast.
in your recommendation 3.
Statute, okay.
Your recommendation 3, I checked those 2 RSAs, they're fine.
Okay, those are fine, and apropos.
Yep.
All right, Representative Balsar.
Yeah, this has nothing to do with that, I agree with the rep, but I just was given a document I'm looking through here, and I remember sitting on the committee before. And the reason I'm bringing this up, I don't want to see this on Representative Polligan's website. It has the son's name on this document. And weren't there issues before and haven't?
There always are issues, we do not want this
Yeah,
out.
so what I'm saying, I'm bringing this up purposely, for the reason because he tends to post this stuff.
Well, would you, yeah.
So
Your
how do we
point is taken,
protect
let's
this
not go any
child?
further. Yeah.
You know what I mean, with this
Yeah,
document?
well, let it respond, let it respond. Yeah.
Son's name is blocked out of
Well,
everything,
actually, yeah,
it's blanked out of everything that I have on
oh,
me.
great, thanks. We're gonna keep that up if you do anything like this, okay.
And then we had some other, you might pick out some other details, there was,
Oh, great, appreciate your attention to that, that's very good.
Thank you.
Now, I have also a correction from you, Mr. Youssef, that I have misplaced. Do you have a copy of that correction? You said there was a citing here that was wrong yourself.
Yeah, there was a misplaced citation, and give me
Would
just
you show us where that is right now? Yeah. You can find it right now. I know you gave it to me, and I've not put the drawing and stuff, but that's successful.
It is.
Let me do this, okay? So, Master Nancy Geiger conducted the hearing, so let me put this off, it's gonna come later. Okay, I'm gonna do this later. No, that's
That's
fine.
fine.
Okay, I thought it might have to do with these points.
Nope.
All right, so we are on these points. We are clear about what happens to strike some of that in 2. And I'm going to simply do now, if there are any generalized questions, really see how efficiently we can get through. So we're looking at this document, that you're just giving us this recommendations. These are the GAL's recommendations. And they're signed. Terry Burnson, is this a continuous? It's 07, 08. I think that's enough information. You know, it's the last 2 pages.
Yes, correct.
Of this order. Of this, what is this called? The recommendations, I'm sorry.
Correct.
All right.
This set of recommendations, Mr. Chairman, became a court order, so this is a court order.
Sure. Yeah, but this is the wording of the recommendations.
Correct.
What you're objecting to, right?
That's correct.
So what lines should we look at?
Well, I think the most telling is the first line in paragraph A, no further unsupervised visitation with dad should occur until it is therapeutically appropriate for Luke. She made a determination as to the therapeutic appropriateness of my involvement with my son with no findings whatsoever from an expert in therapy, in psychology, or any other sort of mental health professional.
Yeah.
And so she established a baseline of mental health without the assistance of any mental health professional.
I do need a little help with that, only in the sense that I always need help, because when you say that there's a missing document in a sense, you're saying that without, it's so difficult. Is that whether we're having a difficulty when he says there was nothing there, and therefore what he has to show us is nothing? How would we do that? I can have a suggestion on how we would get to certainty that what he's saying. I don't doubt by the way what you're saying, but how do we get to certainty?
The only way would be,
Where would it go?
it would be in the court document, if it existed.
You would need to bring all 11 volumes of the court record in and literally sift through every page.
Well, no, it would be in the docket, right? It would be a docket.
It wouldn't, no, it wouldn't necessarily be, because she may not publish necessarily as a court pleading or submit to the court as a notice or pleading the expert findings. But, you know, like I've said in prior hearings, if there's a justice or a notary in the room, I'd be happy to take the swear an oath. She made these recommendations absent therapeutic expert findings, and I was never able to challenge any would-be expert.
I'm just thinking isn't this innocent until proven guilty? I mean, this is essentially, if she's going to make a supposition, there needs to be something to support it. And he's saying nothing was brought forward, so according to Roxall, he has to be presumed to be fit.
Right. You say that, I'm still on this other question, but I'm wishing you could resolve for me about how I can ensure that there's something there. He's saying it's missing, there's nothing there. You see where I'm just, it's kind of an awkward moment in a sense, because, but yet we have this problem of calling it a finding, and how we say we found that it's an assertion at this point. I apologize for having to recognize that in a way, I don't shouldn't, but I say that only because I respect the citizen who testifies whenever a citizen comes in. Representative Keynes?
Yes, this is a copy of the recommendations of the guardian ad litem that was submitted in February. That's 5 months ago. Do we have a court reaction to this?
Ms. Keynes, this is actually a year and 5 months ago.
Yeah, a year and 5 months ago. Do we have a court reaction to this?
They created a court order out of this.
Do we have a copy of the court order?
You do from
that's
prior,
created from
yeah,
this?
from prior hearings. I submitted my stacks of documents in my earlier hearings. I want to say January, February.
Representative Morgan has a copy of it. Would you like to share it with Representative Keynes?
What's it?
I just asked what the court order.
If you should share it with her, we just mind if you don't, just give it to us, we don't carry the
In terms
conversation
of
across.
the timeline, this is February 11th, 2011, which is 3 months before the court order. There were hearings in April 2011, but so there were some things that happened before February 11th, 2011, so probably not fair to Tracy Burson, if she's making all this stuff up, is not doing this alone, that there was, like your son was examined by a doctor in January 28, 2011, a couple weeks before.
That's correct.
Yeah.
That's correct. And I was unlawfully excluded from that because I had a parenting plan in place wherein I had joint parenting responsibility, I was excluded from that. I was unable to meet the witness face to face. That's,
Unless you're saying that, he's saying that this, he's saying, if I can put words in your mouth just for a second, it sounds to me like he's saying that there was a therapist involved who she could have been referring to.
no, there was no therapist involved or appointed by the court at that point.
What was your point then, Representative Morgan?
I'm just saying that it wasn't totally making it up, there were qualified professionals working with the son. Perhaps not that
It
was.
sounds like you're saying that's not true.
That's not true. There was a doctor that was appointed to provide therapy services to my son subsequent.
That's what this reported.
Correct.
Is that what you're looking at?
And that same therapist actually testified that the allegations, the unfounded results from DCYF were consistent with clinical practices of psychology. So he agreed with DCYF these allegations were unfounded on the record. So
All this after the order.
this is all after the fact. Now, whether or not my son was taken to an emergency room, Mr. Horgan's correct. An emergency room visit doesn't qualify as somebody who has sound credentials to be able to evaluate my son's mental state or his psychological condition as a result of an hour-long visit, which was obviously made in a very stressful, under very stressful circumstances.
Was that a psychologist, however, or a psychiatrist who was there?
I don't believe so. I don't know for sure because I was excluded from the.
Yeah. I think I had recommend teams. Did I recommend teams that is that all you wanted, was that for now?
Yeah.
Okay.
Thank you.
Yeah. Representative, were you in the middle of, you were in the middle of trying to develop another? Yeah.
No, I think it's been addressed, thank you.
All right, so, but you wanted to say something further to help us out with my dilemma, at least, and I think my committee's dilemma, that how can we be sure this is simply, how can we,
Well, I'd like to expound upon what.
confident say that this happened?
I'd like to expound upon what Representative Cohen said. There is a presumption that fit parents will act in the best interest of their children. That's Troxel versus Granville. It was restated in a case that
Oh,
was.
wait a minute. We can get to that. We already believe that, by the way, and all of us have heard that testimony. I don't really.
Sure.
We're really on to the question of this GAL's witness testimony that where she takes on the role of doctor.
Well, I think the burden of
How
proof.
do we, yeah.
Sure, the burden of proof would have shifted to Tracy Burnson to come and provide rebuttal testimony, which she never did.
There is some.
And I've been, with all due respect, we're all working very hard to get through all of these, specifically all the volunteer legislators. The fact is that
No, thank you.
I think this is the
I'm
ninth
gonna make a
hearing, and
comment.
Tracy
I'm gonna
Burnson's
make
never
a-
shown up.
I'm going to make a comment to the committee on those grounds. I've been told, I've been instructed by the speaker that when that happens, we do have the privilege of doing that. They've had their opportunity. We can choose or not choose to believe the witness. That's where it is at this point. I was looking for something harder, however. So that lacking, and yet she did have an opportunity to respond. I'm not just, I would agree with you.
And with all, it's impossible to prove a negative without the entire file, so.
We've been here a while. So go to point 2 on that, the second point on, point 3 would be recommend the imposition of extrajudicial conditions. This JL recommended the imposition of extrajudicial conditions on reunification contrary to 2 sites and contrary to the presumption that the fit parents are presumed. Okay, we understand that concept and believe in it. 461A and 2. All right, what were the extrajudicial, is that also in this here? Show us.
Yes, it is.
What line that would be?
Paragraph B,
Yeah.
very quickly, Dad must sincerely acknowledge the behavior to my son that he experienced, which caused him to have these feelings. So I'm now required, in order to exercise parenting, that I have to acknowledge something that never happened. Number one. Another, and if we go, I'll point you to paragraph F. Dad shall enroll in a parenting course and show by transfer of knowledge that he has developed better parenting skills for a child Luke's, son's age. Dad shall report information about the class to be taken to all parties, etc., etc. The point
You
is,
don't have to make a point.
okay,
This is clear to everybody.
this is placing conditions
This is-
upon a fit parent's
This is a
ability.
fit parent being told all this stuff and made to admit things he's not admit, that he's already been found not necessary. We're with that point. I'm with that point. Anybody else want to discuss that point? And Representative Itza is pointing out to me in front of here that these are incorporated into the court order, which he's looking at out of the file.
That's correct.
If anybody wants to see that, we can show it to you, or you can take it word for it. Representative Varga, on this point, agreed?
And Roman, letter F on recommendations, there's, should be a still stipulation to the mother. Did the mother object to that, or did you?
I'm not aware
This is completely irrelevant.
Yeah, I'm not aware of the mother's,
So,
the
don't
mother's
answer, I appreciate it.
position on this, yeah.
We're going to point 4. I don't see any more discussion. Would somebody actually, Representative Kapler, do you have the RSAs? Would you mind pointing out to us, at least give us some idea what RSA 461A2 and A6 serve? Or describe conditions of reunification, I take it, is what that's about. Just for the sake of the committee who wants to make a vote.
461A2 is a statement of purpose.
Okay.
You want me to read over?
Well, no, do you see a line in there that would have to do with extrajudicial conditions on reunification? In other words, what we just saw in those 2 points, B and F, we're looking for support in RSA. If you don't see it immediately after, Mr. Youssef, would you show us?
Sure, gladly.
Oh.
See, the extrajudicial conditions on reunification are, they speak contrary to the state statement of purpose in RSA 461A2. Because children do best when both parents have a stable, meaningful involvement in their lives, it is the policy of the state, unless it is clearly shown that in a particular case it is detrimental to a child, to, subparagraph A, support frequent and continuing contact between each child and both parents, in subparagraph B, encourage parents to share in the rights and responsibilities of raising their children after parents have separated. And so the problem is that she is predicating the state's statements of purpose on something that is not enumerated in the statute.
I think there's a clear disconnect between the statement of purpose of parenting plan. The state would have to show that it's detrimental for his son not to be in contact with him, where the position of the court order puts, without showing that it's detrimental, puts stipulations on when contact would resume.
So you're agreeing that these 2 points are what are being affected?
Yes.
Is there further discussion?
In legal contemplation, it's the burden shift has been unlawfully placed on me.
We have that. Yeah, we have that. Representative Hardy?
Thank you, Mr. Chair. So the main request here you're objecting to is that they want you to enroll in a parenting course, and
We're actually doing findings related to what the guys did, what the officials did. How can you help us with that?
all right, that's fair enough. And I see what the argument is that he shouldn't have been ordered to do these things.
Right, because he was not educated on fit on any grounds. Right, that's
I
exactly right.
guess I'll wait the question I was going to ask, like why you, I guess probably wait till the process and the enrollment is, which is why you didn't go ahead and try those things to see if they help.
To answer that question, I did under duress, but to answer your question, it's not the parenting course that I have the problem with. I found it informative and useful, but in fact, I don't like a government that is going to get involved in my private affairs and violate the law, the very laws that it is supposed to be enforcing and
That will
upholding.
be your objection, Representative Avard.
No, I was just gonna say, I mean, it didn't need to be here on the parental thing, because it's already part of the divorce, that's a requirement on both mom and dad, so I don't even think that's an issue. I think somebody made some bad decisions here.
So are we past that point? Number 4 is recommended unlawful prior restraint of petitioner's free speech by restricting him from talking with his son about the subject of love. Now, you have that in quotation marks. I don't understand why and whether it should go back into quotation marks.
The only reason I put it in quotation marks, Mr. Chairman, is because I'm kind of trying to characterize I'm using the word love to characterize what was actually quoted in the recommendations. Paragraph E, the highlighted portion.
So I would phrase it, maybe then let me ask you, would I phrase it better than say that from talking with the son about what the GAL characterized as the subject of love? Help me, help us. Represent this good.
Under no circumstances, the recommendation is, under no circumstances should Luke be questioned about whether he loves or misses his dad during these telephone calls. So, in that, he can't say, son, do you miss me?
That would be a violation of a court order. But it's at loggerheads with the entire history and heritage of free speech. And it's also it's an abrogation, not only is it an abrogation of that right, but it is, it really frustrates the very fabric of the family, which I'm trying to repair. And if I can't repair it by speaking of love with my son, it just promotes alienation.
That part is a certain state represent Catholic.
Thank you, Mr. Chairman. That particular sentence, or whatever you want to call it, is actually in 461A6. Let me read A6.1 and then I'll read the sentence that I'm referring to. In determining parental rights and responsibilities, the court shall be guided by the best interest of the child and shall consider the following factors. And factor A is the relationship of a child with each parent and ability of each parent to provide the child with nurture, love, affection, and guidance. And I think you could quote that 6, paragraph 1, subparagraph small a at the end of that sentence.
I would agree with that. Representative, I mean, is there any further questions?
Quick question, yeah, when I read through some of these recommendations here, and I'm going to just real quick on the first one, that no further unsupervised visitation should occur until therapeutical appropriate for Luke, for the son, excuse me, I'm saying. But anyways, was there any type of medical documentation that reinforced her making these comments?
No, she acted as the expert, extra precipiently. She stepped outside of her field of expertise. She's a lawyer by trade, and she's a certified guardian ad litem. She's not a mental health professional of any caliber.
Okay, then was there any other medical documentation that disputed her comments that, you know, you said everything was unfounded and all that, all prior to this here?
No, not until afterwards when another therapist became involved, at which point he agreed that the characterization of unfounded, he agreed that the allegations were not, the allegations that the guardian ad litem had made against me with DCYF, he said, no, Josh's practice of assisting his son with hygiene matters is absolutely not something called into question for a child of this age. So, if anything, once the therapist finally did get involved, the therapist supported my position. Yet, that didn't happen until a little later on, but these recommendations became the law of the land by that point. My hands were already tied behind my back at that
Would you help me now? You've created the question for me, and that is, recommendations like this come out of the GL's hands, so they not come to you before they get to the court?
I received this the morning of the hearing. And it was 27 pages long. I mean, not to mention,
So
Mr. Chair.
My point for the committee is that obviously he doesn't have time to do due diligence to defend himself. And a court order came out, the court order that came out that same day.
It did. In fact, what happened was it was
referred to this as an abuse.
It was an unknown. It was an unnoticed hearing. This was a hearing that was noticed as a trial management conference.
Why did we miss it? Why did we miss it?
I know he brought that up in part.
Yeah, he did.
Mr. Chair?
I would consider a recommendation that we bring that back into this. Sounds so important.
What you just brought up, Mr. Chairman, is I've seen happen in many courts that we sat in, where the lawyer, right then and there, gives his motion to the court. Is there a law, maybe something that's already out there that says within 7 days, within 14 days or something.
It's the
And if
statute
there
of
isn't-
expert testimony.
The public is not.
Mr. Chairman, if there isn't, then it definitely needs to be added, because I've seen it happen
No,
many
we're
times.
going to listen to some people who know something about this. Mr. Youssef, could you
Yes,
tell us what you know about it?
furthermore, the guardian ad litem, being an amicus curiae, a friend of the court, is required to submit her report 90 days before the hearing.
90?
90. And that is
Somebody
codified.
help me with the citation.
I
Where's
don't
the-
have the exact citation, but I believe it's in chapter 516.
Somebody needs to work on this.
It's on expert
We can't leave
testimony.
voting for this bill today.
Makes sense on it.
If we don't get to it, by the way, I will pick up after lunch on somebody else. We'll have time. All right, we do have a serious issue with this because of every kind of due process provision, but also possibly it looks like RSA breach. So I will move on to a point, without further discussion of the prior comments or statement of four, if there's no further discussion or reason to reject that. I really would hope you'd be looking at it with that in mind, not be able to accept what's here, but to make sure you believe it. So go to point 5. Recommended as a condition to see his son, the petitioner enroll in a parenting class and separately in individual therapy, contrary to the Troxel presumption that fit parents are presumed to act in the best interest of their child. I don't quite see in this phrasing, I mean, it actually, I'm not sure I fully grasp the status of that.
I'm not allowed to see her paragraph A of the recommendations turn court order. I'm not allowed to see my son until the conditions in paragraph F and I are satisfied. And so I was not, and I'm speaking in past tense, I was not allowed to see my child until I took the parenting course, showed by transfer of knowledge, and then again in completing that paragraph, of course. And then again in paragraph I, dad shall enroll in therapy with this is very interesting, with an individual therapist to address his anger toward mom. Well, I had never been determined by a psychological expert or a mental health professional of any kind to have any anger toward mom. I am very angry at the situation that I had my
Come back to where.
So the point is that this is another example of how she is assessing psychological
I
conditions.
want to understand what you're claiming. No, he's on a different point. I know you're going to talk to the other point, so hang on for a second. Recommend as a condition to see his son, the petitioner enroll in a parenting class. Now, so what we have in front of us here is that you got a JL recommendation that should have gotten to you 90 days before, and it comes down and actually takes away your ability to see your son. Slam bang right there in that spot.
In an unnoticed hearing by offers of proof, which is
Right. Without having seen it before and any chance.
absolutely.
And so that's the general sense of this. And then your point now is to say that they are, this is contrary to the presumption that fit parents are presumed to act. And that's what I'm trying to understand, what you're really trying to say, that portion, how you're relating those to each other.
Well, what I'm trying to say is that she is impeaching my parenting abilities as though I'm unfit, when the guardian ad litem should have, as a trained professional, taken the stance. Geez, I'm going to hold this individual as a fit parent until we can qualitatively prove that he is unfit. And that must be done in an adjudicatory hearing under the, I believe it's Arena D.
Is everybody there on that now? I am not there on myself. I represent the party. Represent Phillips first. Represent Phillips.
Thank you.
Sorry.
To go back to the question of expert testimony, 516:29-D specifies a number of things about expert testimony, specifically Section 3. These disclosures shall be made at the times and in the sequence directed by the court. In the absence of other directions from the court or stipulation by the parties, the disclosure should be made at least 90 days before the trial date or the date the case is ready to be ready for trial, or if the evidence is intended solely to contradict or rebut evidence on the same subject matter identified by another party within 30 days after the disclosure made by the other party. The party shall supplement these disclosures when required in accordance with the court rules. And then 4, actually.
Excuse me a second, would you, for other purposes, what would you cite? 5, what was that, 5 what? The RSA?
The RSA 516:29-B.
And then section 4 says that the deposition of any person who has been identified as an expert whose opinions may be presented at trial and whose testimony has been the subject of a report under this section shall not be conducted until after such report has been provided. So, I mean, you can't even bring an expert forward if it's supposed to be a report, and the report clearly has to be 90 days unless it's rebuttal, in which case it's a 30-day limit. I mean, it's very clear.
Get your head around this one. Would you make a sentence for us? Would you create a new point for us? Maybe if you don't mind, you know, you weren't so capable, I wouldn't throw it on you. You know what I'm doing here. Thank you for that.
Mr. Chair, if I can-
Representative Horgan.
Yes, I found the same RSA Representative Cohn did, I just thought I'd add parenthetically that it was last time it was amended was by the 2004 legislature, so that's well before. Since we had some other cases where we're discussing what that RSA said at that period of time. It's been in place since July 22nd, 2005, which I'm guessing is 60 days after session ended, so that's,
So it comes up with that.
certainly the time frame is not going to be a problem in this case.
So
Mr. Chair, if I could add just a...
language, you have to.
I'm sorry.
I don't miss seeing you.
No.
So to speak. Anyways, good enough. No, you just have to allow that. It doesn't work very well in a format like this. And having forgotten anything I was going to say, go ahead and give me your...
Under the statute that Representative Cohn just read, she should not have been able to even show up at the hearing and talk. She had nothing to say. She should have had no standing in court that day. But even to back...
Put that in a comment in your statement. Does everyone in the room know what we're going to do here? Representative Cohn is going to write a phrase with a 90-day speech, and to include in that, to include in that a point related to the experts, etc., and then to include the point related to her inability to perform without, etc., etc. So is that clear enough, just those points? And the reason I'm asking whether or not we fully, if you think you understand what I'm doing, you can get phrasing, but I might want to vote on this before we get phrasing. If you understand the concept, I know we don't do this very often, but we have reasons to notice that some committee members are recusing themselves, others will want to, we need to leave, we're not part of that recused group for theoretical conflict of interest issues. So understand that I'm trying to move this right along. I'm not going to break for lunch at noon. I'm going to break for lunch when we can finish this, but I also would hope that all other committee members, like a certain representative down the corner there, would stay until we finish. Representative, that is our last point in this thing. And I just needed to have somebody tell me that they have seen Troxel versus Granville, or if you have a copy of that in front of you, or that we could look at something Troxel versus Granville and confirm for ourselves the concept is as represented. Representative Balzer.
I just wanted to do some clarification for my own mind from Representative Cohn. The 90-day window, this is the gambling of lighting for the child. He's there in court to represent the child. So are you saying that their recommendations have to be submitted within 90 days? Or are you saying when they go to court, every time there's a case of gambling items there, they can't say anything and they're missing something?
This specifically says that the deposition of any person who's been identified as an expert whose opinions may be presented at trial. So that's the key here,
right,
is expert testimony.
Okay. My follow-up, if I may.
So you're saying that because she wasn't recognized as an expert, she shouldn't be witnessing regarding experts, require expert?
I believe that's the argument that's been presented. Is that essentially, your original question was, well, how do we know that there wasn't a finding? And Mr. Youssef says, well, the presumption, according to Troxel versus Granville, is I'm a fit parent unless otherwise shown. At which point you said, well, we don't know if there was any expert testimony. And the answer is, well, even if there was, it would have had to have been presented 90 days sooner. So you can't presume that anyone who was there was an expert unless there was testimony. I believe that
if I understand it
Well,
correctly.
90
That's-
days, though, it was represented to us in a much simpler way. 90 days is that I asked him about the GAL report, recommendations. And he, I believe, said it in 516, it says that required, that has to come forward 90 days, which is that time frame for him to review it and rebut or whatever, as I understand it. It's as simple as that, right?
Yes,
Better be.
because there's a case called Ross versus Gadbois, which deals specifically with guardians ad litem and characterizes them as experts. Now, just because she's an expert doesn't make her an expert in the field of psychology.
You're out of my line of questioning. I'm
Mr.
actually
Chair,
asking
follow up,
you,
Mr. Chairman.
is there a 90-day requirement for something besides experts? I thought you said to us the GAL cannot, that you should have received this thing 90 days ago, and not
Yes,
not
that's my
minutes
understanding.
before the hearing.
Yes, that's my understanding.
That is, now that's what I'm asking you to affirm, if you would, Representative Cohen, could you affirm that that is what's in that?
Mr. Chairman.
Or
Well,
is
I'm
that
going
somewhere
to read
else?
the language again because I think it's important to.
Before you read the language, can I follow up on something that might help you? If we-
You may, Representative Belcher.
Thank you, because I wasn't finished, that's why. The gallery ad litem or laws may say different, that's why. You're saying an expert. The court ordered the gal to represent the child, so I would think we'd have to use the gal laws
Well, let's,
in her recommendation,
let's
that's
see,
why.
let's see, yeah.
Let me, you might be right, Representative Baltasar, but if I read this, because I think you'll see that these disclosures shall be made at the time and the sequence directed by the court, in the absence of other directions from the court. Once again, the court has discretion. And I think that's the issue here, is that if the court says, I'm going to go ahead and allow this, then it allows it. I believe what Mr. Youssef is saying is, look, if this is going to be presumed to be on the level of expert testimony, to say Troxabosis Granville doesn't apply, you are not a fit parent based on that report, that the law seems to make very clear here, he should have time to look at that report, 90 days.
So because she
And he didn't
presents-
get anywhere near that, he got it the same day.
So would you be claiming that any GAL that comes in then is an expert because they're defined as an expert?
Well, I believe he quoted a case where,
They're characterized.
Only if that works for this.
and I'm not saying one way or the other.
Yeah.
They're characterized as experts whose job it is to compile expert findings. They themselves are not experts in the way of providing knowledge about a particular subject matter. So their duty is to fact find, compile the report based on
Right,
facts.
so what you're saying here is that because they use the words therapeutic a couple times, it's presumed to have been on the basis of other experts than themselves, which I've
Correct.
never heard. But which, had there been anything going on, there would have been 98 notice.
Correct. Yes, sir.
Representatives.
I think along the same argument is that because this court order deprived him of parenting time, which can only, per RSA 461A:2, can only happen because he is to some degree unfit, you would require expert testimony to cause that to happen. And if so, in order for that to happen, in order for that testimony to be admitted to cause the deprivation of his time with his son, it would have to have been expert testimony and therefore given to him 90 days in advance.
That's correct.
Also then comes back up though about whether this judge has the ability to ignore it. Representative Belcher.
Okay, then I agree 100% what you just said, but there's still pops in my mind was, at the time this was presented, was a motion made challenging this here to comply, because the judge has the right to
Was that
accept
John
or not.
on the spot?
No, there wasn't. I was represented by incompetent counsel who I'm suing.
Mr. Chair. No grounds?
Yes, malpractice. Yeah, gross negligence.
This one. Representative.
Talking to Representative Kapler with the shortening we did for finding number 2, where we shortened it down to RSA 51629-A. I believe it's the same issue, and we should just add in and 51629-B, because I think that covers the issue of the timing. And other than that, I mean, it seems the description positive, in fact, the psychological condition of the minor child without being an expert herself, with no expert psychological findings or report, and report from any testimony that is the product of reliable principles and methods contrary to 51629-A and 51629-B. Because 51629-B says if there was a report, it would have had to be produced in a timely manner.
That should be fine.
That's very acceptable,
Yeah,
yes.
thank you, that's excellent work over there, you gentlemen. You can stay on the committee.
Mr. Chairman, for Representative Vitsa,
I'm sorry, you're recognized, yes.
thank you. The GAL laws, which I don't have in front of me, isn't there a breakdown which identifies them as certain, if I remember right, certain qualifications that to be a GAL, that gives them the right? Because I think we got apples and oranges here, and the expert here, so
I don't think it matters anymore, actually.
it don't matter?
No,
Okay.
they were covered already for what happened.
Right.
If you follow, I mean, if you didn't follow what he said, we could have to do it again, but.
Okay.
You mind? Yeah, for sure, okay. So then, one question at 7, family division, is it actually supposed to say, or this is not in your bold now, but it's supposed to say, fail to comply with family division administrative order? You see my question mark there? Is that what that was? Or what is, you said administrative order, but it was very unclear what that is.
Yes, it's the Family Division Administrative Order 2011-03.
That's for my correction, a few yours if you don't have it in there. Cross off a question mark, then that was my question. Yeah, I wrote something for you.
My recollection correct, that was it was the last time you hear about, she sent the bill out on she was being covered by the GAL fund, which ended on May 31st, and she sent the bill out on June 3rd for services that rendered it right up to May 31st. And that's what you're saying.
That's correct.
Yeah.
This is kind of the capstone to her appointment of violating authorities.
All right, without further discussion, everything else you've seen, your corrections were made. Representative Kaplan.
Thank you. In the middle of the second page,
Yes.
it says, at the end of the sentence, it says, New Hampshire Circuit Court Family Division Rule 1, period 26, F.
Yes.
I would suggest that we remove that rule in there because 126 is motions, and it has it says nothing whatsoever of a requirement for a motion. I agree with
Is
the
there a
sentence.
requirement for reconsideration of the motion? When he
Right,
makes
it
a motion?
doesn't say that the court has to do it. There's nothing that says that the court must do it in that paragraph. I would just leave that paragraph out. If there's some other place in the rules that says that, you know, that's a different story. But 126, the complete 126 motions, including F, never mentions that it's a requirement of the court.
So what should we be looking at, Mr. Youssef, instead? What citation would we be using?
And I completely understand Representative Kapler's point. I guess my counterpoint to that would simply be that a hearing officer, marital master, judge, etc., has a ministerial duty to adjudicate motions.
No, he's asking where it's found.
I'm just saying that's the entire body of American jurisprudence, is the decisions need to be made on
You cite
motions.
a family division rule 126F, and you're agreeing, I think, that he is irrelevant.
I guess what I would say to that is, though it doesn't explicitly say that, I don't believe that the lack of explicit direction to adjudicate motions doesn't obviate or preclude the requirement to conduct his ministerial duty to adjudicate a motion to reconsider.
Understand that, so your phrasing, though, would be contribute when he declined to issue orders, and then you would want to cite for us something, and it would be in law, it would be in statute, it would be in Constitution. Representative Cohen?
Yeah, I think the problem here is the word contrary, because it may not be contrary because if it's optional.
So
Mr.
per?
Per, because then the allegation is still true that he felt that the committee finds marital master Leonard Green also contributed when he denied petitioner due process of law by declining to issue orders on petition's motion for reconsideration per the rule 126F.
Would that work for you, Reverend Campbell?
Yes.
Would you accept that? Yes. All right, then I have this one correction, and would all everybody go to Master Geiger, which begins at, is that on the first page still? I believe. So Master Geiger, it says, conducted a hearing that affected petitioner's parental rights without proper, and that's what, so the second page is number 1. And it will say without proper judicial notice per. And the site, there's actually a Supreme Court site, which we haven't seen, and do you have a copy of that?
I do, yes.
And so we'll look at that, and what I have here in his writing is, and it's just a correction, is Duclos versus Duclos, 134, NH 42, dash NH, Supreme Court, 1991, quoting Murphy versus Murphy, 112 NH 507, New Hampshire Supreme Court, 1972, number 1. So that's the site, and he's going to provide that for us to quickly review at this moment to see whether we would add that, or would we be subtracting the RSA and just putting that in its place? It looks like we're taking that out, taking what's in there out, right? So we're moving RSA 173B1 and 2. Yeah, number 1 at the top of the page, RSA, where it says per RSA 173B1 and 2, we strike that, and this language will come in. Why don't I wish I'd copied this now. Why don't I send this language around, and then you just take a good look at that for yourself. And get it back to me. You want to strike that? Well, go ahead.
I want to make sure that we shouldn't.
Yeah, no, right. We do look at it.
173D colon.
B1 and B, colon 1, 2. 1 and 2.
Mr. Chairman, that's going around. Do you have a question about Cox versus Granville? Because I've got it up and.
I have a copy of it right here.
You do?
Yeah. And you got to keep that moving. So Taco versus Granville's coming around. It's been around this way up there. So that correction, and so you have that in your hands, the Supreme Court decision or whatever that is?
I passed one copy around, and I do have the other, my own copy as well. The Duclos versus Duclos quoting.
Trust us to give you the second copy back. I'll bring it the other.
I don't mind that at all. Let me find the
Do
right
come
page.
looking for it. Don't trust us. Do come looking for us. We work for the government. We really don't, actually.
They're the good part of the government.
173, colon B, dash 1.
That is not correct there, Mr. Chairman.
It's not correct.
No.
It's just something wrong.
Yeah, it was a.
B-1 is the definition paragraph.
Oh,
Everything in there is
Well, there's
definition.
no has to protection of person.
yeah, okay. Completely irrelevant, so we are definitely striking. All right, thank you for looking that up, gentlemen. And so you sent copies both ways? Where'd the other copies
Yes.
go? This way? The other one's going this way. Representative Cohen, did you get to some, oh, no, we're good. Yeah, we didn't need language. Thank you very much. No, we're good. So I strike that from my nonsense here. All right.
We added the single.
Mr. Chairman, if you wanted to leave that RSA in there, you could leave it in there as just colon B.
Okay, Representative.
Colon
That-
B
that-
is
You mean after 2, colon B?
If I may,
Yeah, please.
if you look at the title of that section, it has to do with protecting persons from domestic violence. I don't believe
don't really.
Yeah, it doesn't.
it's not pertinent to this chapter of law, or this title of law.
So I'm looking at Morphy versus
Does
Morphy.
anybody know what chapter America Marshall's come in?
490D colon 3, no,
490D?
490D colon 9.
10.
You know, I recognize more and more the need for a hand or something because people do things, there's a listening that's going on that's formal, and when it's not doing it that way, I think it gets really confusing. So keep that, if you don't mind, just keep that, the hands up thing going on. Representative Hargan?
I guess the front of the domestic violence statute, there's page 5. There's some, these people always send angry emails to their exes, but this is some comments that are probably, sound pretty bad when they're on the paper. So
What does that have to do with, though, in terms of what something we're looking at here?
well, it could
This is a claim that Geiger conducted a hearing that affected petitioners' parental rights without proper judicial notice.
not getting into what she actually recommended or what evidence.
Right, it's the timing issue, yeah.
I mean, good raise.
And the timing, by the way, in Markey versus Markey, it says that reasonable notice meant that the notice sent to a litigant must be reasonably calculated, to give the defendant actual notice of the issue and the hearing. And here you are at a hearing, you're saying that you were standing there at a hearing, you're not even, it's changed to a different kind of hearing. We've heard it a number of times before. Yeah, it seems very relevant, and I don't dispute that. The notice was on. So, how was it represented at that hearing? You said that you were just surprised by the JL's thing and the fact that they actually came to a finding based on it.
Well, we dealt with this in another hearing, but just for purpose of refreshment, the case document index notice reflects that the notice was given as a trial management conference, and it was conducted by offers of proof, which in order to modify a parenting plan, full evidentiary hearing is required under Muchmore versus Jaycox, and that didn't happen. It was kind of a drive-by hearing, to colloquialize it.
Are you ready for a motion if anybody is, if there's something to the discussion? Yeah, you can also hunt for Representative Keane if she wants to be here.
She's away.
She's not able to be here now.
See, right here, I'll be right back. Thank you.
No, he doesn't want, he's heard that. No, he's gonna get to it, what's going on. Oh, sorry. Representative Itzel believes that we should spend a few more minutes on this. I recognize Representative Itzel.
Thank you. Having perused the divorce statutes, there is no time requirement for notice of the hearing. It's all a matter of court opinion. So I would make a recommendation that we introduce legislation next year to make a specific requirement of advance notice on hearings for divorce. Include ambush.
We putting that?
The new last recommendation would be number 7.
Number 7, legislation for specific requirement of advance notice for, what was your, for what? For what?
Well, hearings in divorce statute, in divorce cases, we have no statutory requirement for how much notice
Is
is
there an area
required.
where that would go that you know of in the RSA?
No, we'll let
All right.
them figure it out.
Is that a point of discussion? So the discussion on that point, we have to use reasonable, seems reasonable. All right. Then, that addition, and the changes you've asked me to make, which I can go through again if you need to. Representative Deborah.
Yes, before you vote, if you go to, on page 2 there, if you go to number 2,
Yes?
where it says, approved a parenting plan that does not comport with New Hampshire RSA 490-D:9, and I read :9,
I don't know where you are.
right in the middle of page 2.
Oh, no, okay, there's several, three
And we're
different.
talking about a parenting plan,
Okay,
and I read,
it's about 15 lines down, so.
yeah,
And
and I read :9 for your information.
Yes?
All recommendations of marital masters. All recommendations of marital masters shall be signed by a judge. The judge signing such recommendation shall certify that he or she has read the recommendation and agrees that the marital master has applied the correct legal standard for the facts determined by the marital master.
Yeah, right, we agree with that, right? You
Yeah,
saw that?
I just wanted to read it for you.
Great, no, great. Clarity is crucial. Representative Balsar.
Yeah, I mean, listen, I'd like to make a motion that we approve this, with the changes.
All right, do you mind having the motion made out, Monday?
No.
Representative Baldessaro makes a motion, seconded by
Second.
Comerford. Oh, Well, that's right. yeah.
Moving along, Mr. Chairman.
You're
That's-
doing very well. I can't have Representative Comerford do it.
I'll
Second.
second it.
I second it.
I'll second it.
Who's not recusing from this? Representative,
I'm not.
Representative Burt. And further discussion. Representative Lodge, you have your hand in it.
I just wanted one big one clarification. Representative Keyes is in another meeting. There's where she's unable to be.
We have to move along again, that's what I didn't, I think I did warn her before, and I was trying to get this done before lunchtime, so. So without further, would the clerk please call the roll and begin with the members, believe it or not, who are actually full-time, appointed members,
Representative Brownberg.
as opposed to,
Yes.
Yes.
Yes, yes.
the motion is to accept the report.
Accept, yes.
It's a positive.
Representative Horgan.
With changes.
I guess Representative Avard, but I have to abstain because of, I endorsed Mr. Youssef in his campaign, so I abstain. Representative Hogan.
Yay.
Representative Itzi.
Yay.
Representative Cohn.
I have to abstain for the fact that I endorsed him in his campaign.
You endorsed him as well?
Yes.
Representative Byrd.
Yes, yes.
Representative Comerford.
I guess I'm in the same boat as you guys. I endorsed him too, so I can't vote.
All the way down here. no
You endorsed Mr. Keith?
Youssef, I
Oh,
did.
okay. So abstain. Representative Kapler.
Yes.
Representative Baldessaro.
Yes.
Representative Welch.
Yes.
Representative Itza?
You already asked me.
I thought you, I got the list.
Don't listen to me.
I'm supposed to listen to you. Representative Deloge.
No.
Did I call everybody?
No,
Representative Ingrid.
there you go.
Yes.
8 to 3.
1, 2, 3, 4, 5, 6, 7, 8 to 2.
8 to 3 abstentions. I appreciate that even though there is nothing in our House rules requiring you all to recuse that because you chose to and were encouraged to by the speaker, you did this to avoid the appearance of conflict, which is something like you're a good buddy with somebody on the committee, which is very personal information, so appreciate it very much. Representative.
Yeah, write in the notes that the members that did recuse all those supported him, but
Yeah, you can do that. I mean, it's true.